Welcome to Chapter 5. These next two chapters have a lot of content, but they are, to me, when we're really getting into the thick of the program, the introduction class. This is when I really love getting into these topics. So there are multiple videos that are embedded within the presentation. I'm not going to play them because it won't let me record and play and do all that at the same time. But I'll also post not only this recording, but the PowerPoint that has the links in it. Some of the videos I have uploaded into or linked to in Blackboard, but some of them you'll have to get through this actual PowerPoint. So here we go. Chapter 5, the American Legal Heritage and Constitutional Law. So the English colonists brought the law of England with them when they came to America. So we have the same type of general system of common law as what we had when we were in England. American law has developed, however, its own unique characteristics over time. We've become extremely, a melting pot, for lack of a better word, of ideas from all of the different country settlers that were here. We have some Spanish influences, French, Mexican, and just keep in mind that it's an ever-evolving system. So, as I said, sources of law. We had English common law, a little bit of French and Spanish civil law. We have the Constitution, and then each state has their own constitution. Federal and state statutes, local ordinances at the county and city level, or whatever your municipality might be called. We have administrative agency rules and regs, executive orders, and judicial decisions, case law, common law. Okay? So there are four main sources of American law, and I will ask you this over and over again once we're able to meet again in person. I ask this question throughout all of the courses that I teach. What are the four main sources of American law? Okay, primary sources. Primary sources are the law itself, and secondary sources explain the law. So the four main primary sources of American law are constitutional law, common or case law, statutory, and administrative. And we're going to talk about each of those throughout this presentation. So as I said, there are also secondary sources that explain the primary sources. Books, articles, legal encyclopedias, law journals, attorney general opinions, all that help to summarize and explain primary law, because it's not always straightforward, and sometimes you need a little help. This video will walk you through the four main sources of law and give you some examples. Keep in mind it's a little bit of an older video, so there will be a piece in it talking about same-sex marriage. It was prior to the 2015, or this video was created prior to the Supreme Court's 2015 decision regarding same-sex marriages. So it's going to, in the video, talk about making it sound as if one state or only a few states allowed same-sex marriage. So this was before the decision came down. The next video, and if you have never seen any of these, I highly recommend you going on YouTube. These are from a PBS show, and it's Crash Course. This is one of the Crash Course of U.S. history, and it focuses on the Constitution, the Articles of Confederation, and federalism. So make sure you take a look at that. It's relatively long. It's like about, I think, 12 minutes or more, but it's a good overview. Okay, so what is law? Black's Law Dictionary says law in its generic state is a body of rules of action or conduct prescribed by the controlling authority and having binding legal force. Okay, bottom line, that which we must obey, and we must follow, otherwise we are going to be subject to consequences of not following and obeying. Laws define the type of conduct that is either prohibited or that is required. Okay? So, fairness and flexibility of the law. The legal system is not perfect. Clearly, we see that in today's world. We are in a time of crisis. However, even when we are in the midst of this type of crisis, when we see the legal system go wrong, it is still the most comprehensive, fair, and democratic system. If you do, if you research different systems of law throughout the world, I still believe in our system, even with the flaws that we have. We are still the best there is. We've got lots of work to do, but because of the type of system that we do have, we have the ability to make those changes. We just have to be committed, and we have to make sure that we have elected the right people to make those changes and to propel us to the future. Flexibility in our legal system can lead to some uncertainty in case results. It's always a constant process. So you'll read in your text about the different viewpoints, I'll say the schools of jurisprudence that have different approaches to what our law is supposed to be doing for us as a society, or how these specific scholars look at the law. Some say those who adhere to a school of thought known as natural law think that everything with the law should be based on morality and ethics. Historical schools based on traditions and customs, and that the law reflects changes in the norms of society. Analytical, the decision should apply principles of logic to the facts of a case. Sociological, we are looking to achieve and advance goals and shape social behavior. The command theory believes that law derives from the ruling class, which may not reflect society's morality. Critical legal studies bases law on fairness. Law and economics looks at it from a free market cost-benefit analysis with regard to how our statutes, or the structure of our statutes. So those are all different theories or schools of thought with regard to the law. I think in in reality, we have some combination of all of those. Or law serves addresses some purpose under each of those schools of thought. So what is law? It really depends on your views on morality, ethics, truth. It's defined as a body of rules that have been established and enforced by the government. It establishes what our rights, duties, privileges are as citizens, but more importantly, it also defines what our responsibilities are, what we must do to be good stewards. Law gives us stability, predictability, and continuity. And sometimes that stability and predictability can be negative when we're not able to move forward. But in its most basic ways, it gives us a foundation that we can turn to and know what's expected of us as citizens and what we can expect from our governing bodies. So what are the functions of the law? Well, it depends on what school of thought you adhere to. I personally think it's a combination of all of these. Keeping the peace, shaping, I won't say all of these because I don't necessarily think it should be shaping moral standards, promoting social justice, maintaining the status quo, and that's in a different light than what you might think of. Sometimes people think of the status quo as being a negative thing, but I'm looking at it from the standpoint of we live in relative, well, I know we don't right now, but relative stability. We know what to expect. We know how if we study the law, we can see how courts are going to hopefully continue to behave. So that is what I see when we talk about the status quo. We can have orderly change when we switch, when a new president comes into office. If we are moving from one political party to the other, while we might have some general disruptions, for the most part, it is orderly. It is not violent overthrow of the government like in many places around the world. It allows us, the law allows us to plan for the future. We can know that this is what I need to do if I want to start a business. I need to follow these steps in establishing that business. I know if I go out and drink and drive, I'm going to be subject to these consequences. So you can plan and know what's going to happen and how the law is going to be applied. It gives us a basis for compromise. When we have conflict with one another, we can look to the law to see how we can compromise. What are our positions and how can we move towards the center? And finally, it maximizes individual freedom. We are a country that's built on individual freedom. However, there's also the concept that my rights stop where yours begin. So it's not just about what I want to do, it's also about what is good for the whole. So case law and the common law tradition. As I said, we brought our system with us from England, and we operate under a doctrine called stare decisis. It is the cornerstone, the foundation of the English and the American judicial system. So Latin, it loosely translates to stand by things decided. And what that means is that we have the ability to look to what our courts have done historically in order to predict what they will do in the future. Okay, we have a hierarchical system, which we'll talk about more in just a minute, with lower courts being controlled by higher court decisions. So what the higher court does filters down and controls what the lower courts should do. It gives us some uniformity, some predictability, some stability to know that people with similar facts are going to be treated the same or similarly. Okay? And as we evolve as people, as a culture, as society, then the higher courts can make those changes in the law as they are warranted. Okay, so this video, go back and watch, and it is focused on stare decisis, talking about a particular fact scenario, kind of making it more understandable for us. So what really does it mean? What does stare decisis mean? I love this quote. It is from a case from 1965. It says, without stare decisis, there would be no stability in our system of jurisprudence. Stare decisis channels the law, it erects lighthouses and lies the signals of safety. The ships of jurisprudence must follow that well-defined channel which over the years has proved to be secure and worthy. So just picture that. What it's saying is, what the justices were saying in this case is, or the judges were saying in this case, is that think of the law as a lighthouse. Previous decisions as a lighthouse that guide us and hopefully keep us from crashing into the rocks. So I think that's a great visual for us to describe what stare decisis actually is. And while we're here, I'll talk a little bit about what a case citation looks like. For those of you, if you've never looked at a case before, this is the name of the case. Usually if it is two individuals, it will be their two last names. Here, this looks like that it is an individual and a state, so that probably means this was a criminal case. That's when you would usually see the state listed as one of the parties. You might see the state, or it might just say state, or it could say Commonwealth of, or just Commonwealth. It is in italics because case names need to either be underlined or italicized. When I was first in law school, or started law school, not everybody had a computer. It was rare. I think the first time I actually had a computer was when I started law school, and it was a huge desktop. It did not even have a modem. I had to go purchase a modem and install it into the CPU before I could Access, Lexus, and Westlaw from home. But anyway, that's a little off topic. But we didn't have Microsoft Word at that time. We had probably the most common word processing was WordPerfect. And in WordPerfect, it was, and I can't even remember why, but it was much more difficult to put something in italics than it was to underline it. And so if you were typing anything, you would underline your case names instead of italicizing. Well, now that doesn't matter because in Microsoft Word, it's just as easy to italicize as it is to underline. But also at that time, we didn't have personal laptops, and so you were taking physical notes, and I can't write in italics, but I can underline. So many times you'll see that I have something underlined instead of italicized. That's the reason why. And it really doesn't matter as long as you are consistent throughout whatever document you're drafting. So that's the case name, and usually it's a shortened version of the actual names of the parties involved in the case. 208 is the volume, the book number for the reporter, which a reporter is where cases are published. And this reporter is the Atlantic Reporter, second series. And so that's the abbreviation for the Atlantic Reporter. This is the page number 193. Here, this is telling us, because the Atlantic Reporter is a regional reporter, meaning it publishes cases from several states. We have this P in here to tell us it's from the Pennsylvania Supreme Court. Otherwise, we would not know which state from within that region the case was. And then it was decided in 1965. So that's just a little short primer on case names and what is this, all these numbers and abbreviations that you look at and see, and you don't know what they mean. So that hopefully will help. Also, when we came, we brought with us these two, actually there were three types of courts. There were courts of law, courts of equity, and merchant courts. Those have now been rolled into one court, but you can get remedies at law and remedies in equity. Okay, so a remedy at law is something that that the court can physically award you, land, money, anything of value. Whereas an equitable remedy is something that is not so definable. It means that you are asking the court to either stop someone from doing something or force them to do something. Equitable remedies are based on these principles that in order to get an equitable remedy, you have to have clean hands, meaning you have to be in the right. You must not be guilty of something. Equity values substance over form, and equity aids those or rewards those who are vigilant and don't sleep on their rights. That deals with the doctrine of laches, meaning that has a lot to do with statutes of limitations. Basically, it's that kind of a thing, that you haven't set on your rights. You have worked tirelessly to enforce your rights. So equitable remedies, the two probably the biggest are a specific performance, meaning forcing someone to do what they said they were going to do, usually what they contracted to do. And an injunction is to stop someone or something from doing something. The common law today, students tend to struggle with the concept of common law. All common law is judge-made law. It means law that has derived from decisions of the court. And here we have terminology of the case law, which I just walked you through, the name of the case, the parties, the person who is filing the suit, the lawsuit is the plaintiff, the defendant. If it's a criminal case, it's going to be the prosecution and the defendant. If you are appealing a case from a trial court, then the person appealing becomes the appellant, and the person who won at the trial court is the appellee. Okay, so those are just some terms to help you. Judge and justices. Usually the term justice is only for those jurists who are in the court of last resort for a particular jurisdiction. You're going to read, as you go through the program, you're going to read cases where the decision was unanimous for a particular court, or meaning that everyone agreed on how this case should be handled. You could have majority and minority opinions. Plurality, meaning that there's certain numbers who think one way, but there's not enough for majority. So for instance, in a court that has 9 justices and 3 believe that we should find in favor of the appellant because of A, and 3 because of B, and 3 because of C. So they all agree to find for the appellant, but for different reasons. Those would be plurality decisions. Concurring is when a judge agrees with what the majority did, but they would just want to get their specific opinion out there. And then dissenting, that's your minority. That's when the judges feel like those who did not vote with the majority, but believe that their opinion needs to get out there, needs this interpretation of the law needs to be there. And many times when you are drafting briefs to the court, you look toward dissenting opinions to see what's the other side going to do, or can I find something in a dissenting opinion that supports our position and could help to turn that minority dissenting opinion into the majority opinion. So our system is one of adversarial interaction. The parties who are involved are adversaries or opponents of one another, and the goal is to win. Okay, and sometimes that is what people don't like about our judicial system. They say that it puts unnecessary pressure on attorneys to win cases, that it contributes to the lack of integrity for our system. Some attorneys may prolong disputes or obscure the truth in order to earn a higher income because they are paid by the hour. Now, I will not say that does not happen, but most ethical attorneys would never do that. And I know some of you would sit and say, oh, well, that's an oxymoron, an ethical attorney. But there are ethical attorneys, and that's what I strive to be and what I hope can inspire you to work for, or to, for some of you, to move forward and to be an ethical attorney yourself. Okay, so even with those problems, most Americans believe in our system and do